over the past couple of days, we've heard a big to huge debate around the LGBT marriage equality and the protection of marriage, or the or DOMA, or the Defense of Marriage Act, in the United States Supreme Court. I want to take a moment to sort of talk about that, and I'll give you my opinion on the possible outcomes. But in the court case, the court has to make a decision in one particular case, the DOMA case, on the United States versus Windsor. And it could extend the constitutional promise of marriage to all Americans. But it could just as easily narrow the results. And I just want to go through and sort of talk to you about all the possible outcomes and my thoughts, and I think our thoughts here at Fowler Nation about those possible outcomes. The first of those possible outcomes that the Supreme Court could decide on is a marriage equality for all. The simplest and most obvious solution for the justices to is to follow the Constitution. The Constitution guarantees equal protection of the law. All people within the United States, and this guarantee is the most robust when it applies to groups that have experienced a history of purposeful unequal treatment, or have been subject to unique disabilities on the basis of stereotypical characteristics, not typically indicative of their ability. And as LGBT Americans are undoubtedly such a group, the court can simply strike down all marriage discrimination laws and declare that each state must come up with a law that is compliant with the Constitution. Now, I think in the ideal world that we all live in, this is what we would all want, right? The courts say that pretty much marriage equality for all, because everybody gets equal protection under the law, and if in one state you can be married and have all the protections of marriage, you should be able to have that same qualification in the other state, or equal protection. That's the ideal. We don't want that. Now, I want to say this for the record. I think none of these sort of speak to what we heard from the courts, and I think we've heard a lot of comments on both sides we have a lot of comments and a lot of court dialogue, but court dialogue doesn't necessarily tell you, or court questioning, the questioning of the justice doesn't necessarily tell you about what the outcome will be. I think the one point when you speak to this situation, it is something that the Justice Ruth Bader Ginsburg sort of stated in her arguments, when in the questioning, when she sort of said, so you're looking at one marriage to be this great thing of whole milk, and the other one is supposed to be skim milk, and it's supposed to be two different things. And so you're looking, or sour milk was her verbiage. So you're looking at two different types of milk, and you're saying they're not the same thing, and that really doesn't make any sense. The other possible solution Supreme Court can come out with is marriage equality in New York, a punt on what's happening in Alabama. Although marriage discrimination could be squared with the Constitution, Justice Kennedy has a history of deciding gay marriage right cases on a very narrow grounds. Neither of his two leading gay rights opinions followed the ordinary framework applied to the law, and denied equal rights to a group historically subject to irrational prejudice, instead relying on the novel and narrow reasoning. For this reason, it's possible the courts will strike down DOMA, thus extending federal marriage rights to same-sex couples, but punt on the larger question of whether every state must comply with the Constitution. If this happens, the key question is whether the justice will apply the heightened scrutiny to DOMA, a key to the skeptical constitutional analysis that will make it very difficult for any anti-gay law to withstand court review in the future. Now, in this particular point, it sort of speaks volumes to sort of where we are as a country, right? So in this situation, they will sort of say the case doesn't exist, and then they'll say, but even though that case doesn't exist, the opinion will be a lot more narrow position, and sort of apply those rights, but every state would have to sort of they won't have to come up with their own solution to this problem. Now, you look at argumentation that's happened on questioning regarding this possible decision, and you see that the justices are a little bit on both sides, right? You see justices sort of falling to the left and falling to the right, and it sort of speaks volumes to why we did DOMA to begin with. And I think Justice Elena Kagan, sort of said it best when she said, if you look at the congressional record on this, members of Congress created this bill because they wanted to scrutinize people that were part of the LGBT movement. It had absolutely nothing to do with trying to protect marriage. It was more so to condemn a particular lifestyle. And therein lies the problem. Therein sort of lies the biggest problem that we have with the LGBT equality and the gay movement in this country. It's not necessarily about protecting marriage, and it's more so about saying you're wrong, you're living a life of shame, point the finger on you, you're part of the problem, you're the new Sodom and Gomorrah, God didn't create Adam and Steve. All the rhetoric that we've heard over and over and over again, right? And you know, I think to go further on that, what we've also heard, and I'm going to talk about this in a second, so stay with me, I'm going to stay at that. I'm going to come back to that. I don't want to give you that right away because I think it's a funny point, and it's a point that we've heard a lot this week. The other possible option is they can say there's no jurisdiction. The easily and messiest way for the justices to resolve this case is by ruling that they do not have the jurisdiction to hear it in the first place. The real possibility, in light of the fact that that they schedule 50 minutes of arguments of time and on the question of whether or not the court had jurisdiction. If the answer is no, the results could be big, sloppy, and messy. Normally, when the court decided they lacked the jurisdiction over the case, it could hold. It also could hold that the case should never have been brought to the federal courts to begin with. This case, however, presents a unique, unusual circumstances where the Supreme Court may not have jurisdiction to hear an appeal, even though nearly everyone agrees that the trial court that sided with the plaintiff challenging DOMA was within its lawful authority when it heard the case. Because the circumstances of this case are so unusual, it is not entirely clear what will happen if the courts hold they lack jurisdiction. One well-known attorney has told Think Progress, where we're getting this information from. We love Think Progress; they're great. Shout out to them. It would mean DOMA would be invalid in New York and New England, where the federal appeals court struck it down, but it would be valid elsewhere, which would be messy. So in certain jurisdictions it's valid, in other jurisdictions it's not valid. So there's no jurisdiction. I think this is obviously the messiest way, and this would lead DOMA. It would be awkward. This would be very awkward, and this would be a very lurking decision. It would be messy, very, very messy. And I think, sort of speaking about the messiness of this case, right? Let's sort of break this down because people don't really understand how this case has residual effects. This was in the court arguments as well. If two gay individuals, two lesbian individuals decide to get married, and one is a sergeant in the military and the other is a civilian, and they get married in, I don't know, let's use DC. So they get married at Bowlings Air Force Base, which is in a state where marriage equality is allowed, or a gay marriage is something that's legal. And then that family gets transferred to, say, Alaska, right? The protections that the marriage had in the state of New York, they basically become an inferior citizen, right? Or inferior resident because their marriage protections don't apply in Alaska, but they apply in Washington, D.C., or they apply in New York. And those are the federal protections because, the federal protections are the ones that enforce. There's about 11,000 benefits that those families get in New York, they get in D.C., they get in Vermont, they get in Massachusetts, but they don't get them in Alaska. And that means there's not equal protection under the law, which is why there has to be a repeal on DOMA for us to fix this whole situation and fix this whole issue. Now, before I go to break, I want to take a personal time to, the last couple seconds we have left, is to indict all those people that have made all these bogus claims. So yesterday there was a rally, or a couple days ago, there was a rally for, the sanctity of protecting marriage. And they made all these arguments that where there is marriage, there's no abuse. And where there's marriage, there's no sexual assault. And when there's marriage, there's no domestic violence. And I thought to myself, where there's marriage, there's no domestic violence. And you look at the stats and you realize that domestic violence happens with married couples. That's why they've created the laws for them. Just saying. So understand that the marriage movement is a complete